Come on, folks. What are you doing?
He told me you were gonna recess for a half hour.
I said a half hour?
That's what they told us. So I had to go make a phone call. We stepped outside, we came back in and she said, they're calling you to do your thing.
Did I say half an hour?
That's what the lady told us. We were doing a video.
All right, okay. What is your name? Your name, sir? Did you two listen to and understand the rights?
Yeah.
Do either one of you or both of you wish to apply for funding or speak to a lawyer? Ms. Alvarez?
No.
Mr. Alvarez? All right, so lawyer, Ms. Kingsley, your name?
Brianna Kingsley for the plaintiff again.
She just gave me a breakdown saying you guys owe $3183.44 in rent, $140 in late fees, $226.43 in filing service and statutory attorney fees for a total of $354,986. Do you agree that you owe that amount?
Yes.
Do you agree that you owe that amount?
Yeah,
I'm asking you, sir.
Yes.
Can you gonna be able to pay that?
I have already on the 9th, I gave them a money order for 1,680. They said they wouldn't take partial payment and I had to pick up the money order.
Why is nobody taking partial payments suddenly, Ms. Kingsley? Can you tell me?
This is something that frustrates a lot of tenants. From the tenant's perspective, they're trying to pay what they can and stay in their home. But many landlords have a strict policy. Once an eviction case starts, they only want the entire balance paid in full. Surprisingly, even the judge sounds a little skeptical about that policy.
It's always been my client's policy to only accept payment in full.
All right, I don't get that. Somebody else was telling me that earlier today. I'm not sure I get that. I get them not taking checks just for termination. All right, so you got 1,600?
1,680, and that's all of March that I owe. And then on Thursday, we'll have the rest. The office knows, they said it's fine.
I'm gonna give you a judgment after hearing. I'm gonna give you until May 4th to pay, but keep in mind, you're gonna have to
Have rent in there,
for
yep,
May.
yep.
So I'll give you until May 4th writ date, okay? All right, Ms. Kingsley, we got that?
Yes, Your Honor, I'll prepare the
That's
order.
actually a pretty generous outcome. Instead of immediately moving toward eviction, the judge is giving them extra time to come up with the money. Cases like this remind you that sometimes a courtroom isn't just about punishment. It's about finding a practical solution.
Prepare the order.
Just gonna send it over to me. I'll sign it. Just make sure you make your payments then, okay? Have a great day.
Thank you.
Now they can take partial payment. You're not gonna make them come up, hang on. You're not gonna make them come up with the whole thing, right?
Okay.
Owners Management versus Justice Wade, 2601102. Your name, ma'am?
Justice Wade.
Good morning, Mr.
Good morning.
Lechner.
Good morning, Good morning, Judge. David Lechner on behalf of Owners Management.
What are we doing on this one?
We have I had a opportunity. I spoke with Ms. Wade last week and confirmed today in the breakout room, Your Honor, we have a conditional dismissal to dismiss this case. And here are this is what we're agreeing to. We're agreeing to a 6-month probation, which would set this out till October 20th, 2026, as long as Ms. Wade has no further violations of either the lease or the handbook. This case will remain dismissed. If there is a violation, we would file a motion to reinstate the case pursuant to paragraph 4A, and we are waiving the 54-day rule because this set it way
56
out
day.
past 56-day rule, excuse me.
Okay, do you understand that, Ms. Wade?
Yes.
So they're gonna dismiss the case, but it's subject to you complying with all the rules and regulations of Owners Management, policies and procedures and manuals. Do you understand that?
Yes.
As long as you do that, the case will remain dismissed. If you don't do that, then he's going to file a motion and ask me to enter a judgment after hearing Mr. Lechner, and that spells out why you have not been compliant with those rules. Do you understand that?
Yes.
And if I decide you weren't, then you would be evicted. If I decide that you were, well, the case will remain dismissed. Do you understand that?
Yes.
Now, there's a procedure at which there's what we call a 56-day rule. So he's telling me you're willing to waive that. In other words, if there's a violation in 4 months, more than 56 days would have elapsed. Well, I mean, I guess you could just file a motion anyway with the motion to set aside the dismissal order, but at any rate, do you waive that 56-day rule?
And just like that, another case gets resolved without an eviction, at least for now. But notice the catch. One violation during that 6-month probation period, and this case can come roaring right back into court. That's a second chance, but it's a very fragile one.
Yes,
And you have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
yes,
Colin Beth. Any questions?
no,
All right, Mr. Lechner submits your order and he has your permission to sign your name, correct?
correct.
All right, you are all set and I wish you well. Good luck to you.
Thank
So
you.
let's
Thank
have
you,
somebody
Judge.
call Brownstown. Your name?
William Walker Mulhern.
All right, so I set this for sentencing this morning. You pled guilty.
Nobody's answering probation.
You pled guilty to this violation here. And the violation alleged that you failed to submit to twice weekly testing on April 4th, that you failed to refrain from consuming alcohol or controlled substances, and that you submitted, that you were positive on a test for cocaine on April the 6th. I told you I wanted to schedule this for sentencing. Before we go on, I want to advise you, you have the right to an attorney, and I'll be happy to provide you with one at public expense if you would like one. Would you like one?
No.
You pled guilty here to attempted possession of a controlled substance. You were on probation on the sobriety court for 2 years. I was told that, so therefore you have 5 days credit coming. I don't remember if I gave you credit, were you arrested on the date of this? I'm
No.
talking about on the date of the offense, September 5 of 23.
Yeah, they took me to jail and they never held me.
Okay.
They cleaned it.
Elizabeth Watson.
So on my view, do you want a lawyer, first of all?
No,
Are you sure?
yes.
So you have 6 days coming. Anything you would like to tell me?
I made an appointment. I talked to Beth earlier and I shouldn't say this one, but I went to pay my insurance to $800. And then I called around all day and either they'll accept my insurance with a waiting list, but they don't pick you up from jail, or they only do it with the state insurance. So I went ahead and I called my doctor and made an appointment later on. It's May 28th at 8 a.m. with Ms. Akram to get a referral to see a psychiatrist because I think I need medication. That's all I'm saying.
How,
I've been judged.
wait, slow down. Have you figured something out here?
So he has Blue Cross and Blue Shield. So
Right.
after court last time, we talked again. And the plan was for him to renew his insurance because as long as he has private insurance, he can only go to what would be obviously in his neck. So he had been to Elmhurst before, and that was kind of the goal as he left was to get with Elmhurst. But as Bill's indicating, there's a waiting list for private insurance. If he was on Medicaid, Medicare, if he was going through DWIN, they got beds available, but he can't. They won't give that bed to a private insurance. He really is in a hard place.
This might be the most heartbreaking moment in the hearing. The defendant is trying to get treatment, the court wants him in treatment, and even probation seems to agree. But bureaucracy and insurance issues are standing in the way. Sometimes the biggest obstacle isn't the law, it's the system itself.
Really is in a hard place. Not to his fault. He did make every effort. He showed me his receipts.
Tell me how you think I can handle this appropriately.
I don't have I really would have loved to see Bill go inpatient for the full time. Like no jail, go inpatient for the full time. The bad part about waiting lists is it's not something where, well, we have a bed available on this day. If
Will
that's,
they transport him? How can I word this commitment for the jail?
the jail has to have, who's paying for the treatment. And obviously then, the agency and the pickup. Elmhurst is no longer doing the pickup from the jail. I am not aware of any agency at the top of my head that has the jail pickup. Bill checked with, I think he rattled off about 7 probably different agencies to me. None of them do the jail pickup.
I called in Clarkston, inside in Brighton. It's just,
How am I gonna do this?
So the only thing that I can think of, Judge, if the goal here is treatment, which is obviously, I think what everybody has in mind, would be for him to call I'll just use Elmhurst as an example because again, he's used to Elmhurst. Is to call and get an exact date for the bed for private insurance and have him go straight to inpatient on the private insurance on that date. It can be where if he doesn't go and we don't get proof, then the alternative is the full 40 days jail, or 39 at this point, 39 days jail, with the credit sentence.
Too frustrating.
I know, but you have no idea how much this is disappointing.
I understand I let you down, but
It's not letting me down. You let yourself down. You ran a marathon.
You put a seed in me, believe me.
You ran a marathon. You stumbled when you got 600 yards from the finish line, and then you stumbled. You stopped
Wow.
running.
This doesn't sound like a judge who's angry. It sounds like a judge who's disappointed. You can hear the frustration in his voice because he believes Bill was incredibly close to turning his life around. The marathon analogy hits hard because everyone knows what it feels like to stumble right before the finish line.
You stopped running 7 yards before the end of the marathon. I don't get it. I don't understand what you were thinking. Bill.
It's not an excuse. I didn't take accountability.
I
know I could have zoomed in that day, but I'm glad I didn't. I wasn't ready. Believe me, these last 3 weeks at home and looking at her and knowing what I did to her, I'm good. I'll get the help I need through my doctor. I know you don't believe it, but when I get out of jail, I'll get the help I need from the doctor.
If he does go in custody today, Judge, the jail should, obviously, we don't have control over what they do, but they should allow him to continue to make calls to see if a bed's available. I am not sure how that works as far as the commitment, if he does have a bed available, if a new commitment can be sent over to allow him to go inpatient after so many days.
don't know how to word. My thought process is 15 days jail, and then I'll release him to inpatient treatment for the balance.
I think that would be appropriate and that it would allow.
But then the problem is who's going to get him? How are they going to know? Well, he's in a bureaucracy. Wait, hang on. He's in a bureaucracy down there. How's he going to get proof that he can go into inpatient?
Yeah, I don't know if they're gonna allow him to make those types of phone calls. I don't know if the jail does that.
And with my insurance, they're not going to accept me. So it's just too big a hassle. I'll go to jail.
Tell you what, I'm going to leave it like this. Probation's revoked. You to serve 45 days, credit 6 for 39.
And
If
here's
you-
the twist. Even after revoking probation and imposing jail time, the judge is still leaving the door open for treatment. That's a reminder that many problem-solving courts don't just focus on punishment, they focus on recovery too. What would you choose in Bill's situation? Serve the time and move on, or keep fighting to get into treatment?
If you can get me proof, I don't care who's this with you?
My sister.
If your sister can get me proof that you're eligible for there's a bed available at Elmhurst or any other place after 15 days, I'll be more than happy to do an amended commitment, have you released, but it's going to be contingent then. I'll even write it down.
You don't have to. It's a 3-month program with Elmhurst, and I have to get home to her, so I'll do the 39 days. I don't want to prove that I did it. There's no going back.
Well, I'm just telling you, I'm making that available to you. If after 15 days you want, I'll be happy to do this. This pains me gratefully. We have to revoke, remind me, he had an interlock, right?
No, Bill's offense was not a.
Right. What am I thinking? Thank you. Good luck, Bill. I hope you'll come back and tell me you're doing well.
I'm sorry.
It's all right.